Appellate jurisdiction on appeal from the Court of Appeal of Belize, hearing of appeal in BZCV number 3 of 2022 between Caye International Bank Ltd and Rosemore International Corporation. The members of the hearing panel are Mr. Justice Witt, presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnatley.
Good morning, everyone.
Mr. Justice Barrow.
Good morning.
And Mr. Justice Burgess.
Good morning, Counsel.
May we have the appearances, please? Thank you.
I think you should unmute. Yes.
Good morning, Your Honours. In this matter, I appear on behalf of the appellant, Caye Bank International Ltd, together with my learned friend, Miss Sheena Pitts of the Belize Bar.
May it please the court, Priscilla Banner appearing on behalf of the respondent.
Thank you very much. I think the court gave both of you an hour. Doesn't mean you have to talk for an hour, but that is more or less the outer limit. We have read everything that there is to read, so you can be sure that we know the ins and outs of the case, and we would expect you to highlight especially those points you think we should look at with greater interest. Mr. Knox.
Your Honours, I propose to deal with the matter as follows. First, I would like to make some preliminary observations on the facts, which I say are very important in understanding the background to the clauses and how they should be construed. I shall then deal with our submissions on each of the respective clauses that are in issue, that is, say, Clause 14, Clause 51, and the indemnity clause, or the indemnity agreement. And I'd just like to start, as we do in our written submissions, on the judge's findings at paragraph 55, and I believe it's at page 69, of the judge's decision at first instance. And it's paragraphs 55 to 63, which we say must form the starting point of the consideration of this appeal. And we refer to them in our written submissions, and Your Honours, I just refer to them again. But in those paragraphs, the judge sets out what he accepts that Miss Villanueva did when she received the relevant wire transfer request. Can I just emphasize two things? If you go to paragraph 56, it says, Caye Bank received via its online banking platform a message with attachment and bearing message number. So it's accepted that the message went through the online banking platform. Then paragraph 57, the reference email for this message was admin@rosemore.com. So that was coming from a correct, if I can put it that way, Rosemore account. There's no doubt about that at all. And then the judge sets out in paragraph 58 what Miss Villanueva actually did. She looks at the NetTel ID, she sees all the credentials match, and there's nothing wrong with any of that. She effectively checks the wire transfer, which has come through the online banking system. And then paragraph 61, the judge goes on to set out what she actually did in more detail in all that. And then paragraph 63, or 62, I should take you to, Tricia Villanueva felt satisfied that all matters of proper security and procedure had been followed and gave her go-ahead to proceed with the transaction on the strength of the documents and records she had reviewed. She was of the honest and genuine belief, which this court accepts, that the transaction was duly authorised by Rosemore, as she felt there were no indicators suggesting the contrary. My lords, I don't know if you've had sent to you, but I have prepared a speaking note which has got some references which may be of assistance. I'm told by Miss Pitts it has been sent to the court. Whether it's been received by the court, I don't know, but it may be helpful simply because it will no doubt save having to write down references as I go through them. Your Honours, do you have that or not?
I don't have it.
Ah.
And I don't think my colleagues have it either. So that's still somewhere on its way to us.
Well, I shall proceed for the moment as if you haven't got it. And if it does arrive, then from my point of view, at least, all the better. But I hope I can take it relatively quickly. But there are quite a few references which I just want to refer to, although I don't want to go to the documents in each case. But I submit that's the starting point. What actually happened at the bank? Now, there are 2 points in particular which the bank is criticised for in the judgments below. And I just want to address those. The first is, it is said by both courts that Ms. Villanueva should have observed the discrepancies in the signature. Secondly, it is said by both courts that the reference to the instruction that an email be sent to a Gmail account rather than to the rosemore.com account should have amounted to a red flag and put the bank on inquiry. I want to deal with each of those because I say when you look at the documents and indeed the evidence, undisputed evidence, it is clear that there is nothing in either of those 2 criticisms. And if I can deal first of all with the discrepancies in the signature point. My lords, if I can give you, your honours, if I can give you the reference first at, I think it's at page 101. Sorry, it's at paragraph 101 in the judge's judgment, which I think I'm right in saying is at page 78. Forgive me, I may have given you a wrong reference there. Perhaps it's page 101. I just want to check my reference because I see something appears to have gone wrong.
Mr. Knox, perhaps you could stay with the paragraphs. That would make it easy for us to
I think it may be
whatever the
100.
page.
Yes, I think I'm just checking my reference. I think it may be 102. Or maybe it's at, forgive me, I appear to have got given a wrong reference. Perhaps if I can come back to it, but in any event, the judge says that there were visible differences in the signature, which should have been noticed by Ms. Villanueva. And the Court of Appeal takes the same point at page 21. I think I'm right in saying. Sorry, paragraphs 38 to 39 of the Court of Appeal's judgment. But in both cases, it's said that there were visible differences which should have been observed. And I just want to deal with that point briefly. It was indeed pleaded by the claimant, Rosemore, that the bank failed to detect anomalies in the signature. And they plead that in their reply at paragraph 6E of the reply. And I believe that's at page 156 of the bundle. I don't need to take you to that. However, I do respectfully submit that it is not obvious, simply as a matter of common sense, to the naked eye, what the difference between the signature on the transfer request was and the specimen signature at page 148 to 149 of the record. And if you look at, if I can ask you simply to look at 148 and 149, I think there you will see the specimen signatures.
But, sorry, Mr. Knox?
Yes.
May I ask a question?
Of course, my lord. Of course, Your Honour.
Would you agree with me that the point you're discussing is a factual point as to whether there was discrepancy in the signature?
Your Honour, I certainly accept. We're not seeking to go behind the handwriting expert evidence at all. We accept there were visible to the handwriting expert on carrying out an expert analysis differences. What we dispute, and we fiercely dispute, if I may say, was that Miss Villanueva should have spotted them. And the criticism that is made of the bank is that there were observable differences which should have been spotted by the bank. And my point is that whether or not there were differences, and we don't go behind that finding, they were not such that the bank itself should have observed them. And if I may briefly explain why, the first point is, just if one looks at page 148 and 149, you'll see the specimen signatures. That's to say, signatures provided at the time the account was opened. And you can see on the right-hand column in each case what the difference, what the specimen is.
Is it possible at all, Mr. Knox, for your junior to share her screen with with what you're proposing? Is that possible, Ms. Spitz? Could you share on the screen the information to which your senior is pointing, or not?
I will attempt to do so, Your Honor, but I do not necessarily believe I'll be able to. But I'll attempt
very well.
As we go along.
Mr. Knox, it may give you some comfort to know that the registry has just sent on to us your speaking notes.
I'm very grateful, Your Honour, that it will, I hope, speed things up a bit. And for what it's worth, I'm on page, I think I'm on the second page of the speaking notes of paragraph 3. And it's just my submissions on the signature point. And I just wanted to make that my first point is a comparison of the specimens which the bank had, which is at 148 and 149 of the record, and the signature on the relevant wire transfer request, which is at 147 of the record. Now, the only point I wish to make on this is, and I'll make it good by reference to later points in a moment, no one is saying that Miss Villanueva herself should have spotted any difference. That was never suggested. And I'm also making the point that if one looks at it cold, one would say, well, how could the normal man or the normal woman in the street or in the bank notice any difference such as be put on inquiry? That's my simple point. And then secondly, on the same issue, and I'm now dropping down to subparagraph 3 of paragraph 3, there was no expert comparison of the signature on the signature cards, which you see at 148 and 149, and the signature on the disputed transfer. In my submission, that's an end of it. It's all very well saying, as the expert did, I've looked at other signatures or specimen signatures of Mr. Connor. The only relevant question was, what's the difference between 147 and 148? The third point is the expert's conclusion at 454 of the record. And if I can ask Your Honours to look at that. Your Honours, you'll have seen this already. But I just want to draw attention in particular to what one sees in the conclusion in the first paragraph. She says, essentially, last 4 lines, I'm of the opinion that the wire transfer contained a collection of observable physical construction differences of the specimen signatures to lead me to opine that the signature was not a true representation of Jason Connor. Your Honours, we don't dispute that. This is 454. And then the handwriting expert continues, even though the signature on QD1 contained class characteristics of the general signature formation, giving similar pictorial appearance, I'm of the opinion that it lacks individual characteristics and variations not consistent with those on the specimen signatures. So in my respectful submission, all that is saying is that there are obviously class characteristics giving a similar pictorial appearance, but that they are individual characteristics are different. But, and this is the point I want to make about the expert report, the expert does not say that the differences were such that they would have been observable or should have been observable by a reasonably careful bank official. There was simply no evidence to that effect at all. The next point, and again, I'm on the same issue, subpara 5 of the speaking note, it wasn't even put to Miss Villanueva that she should have spotted the differences. Her cross-examination is at 1075 to 1098 of the record. At no point is it put to her that she should have spotted the differences. And when Mr. Roaches was taxed on the point, of course, he wasn't the person responsible for looking at the differences. He said at 1058 in cross-examination that no bank in Belize has a handwriting expert. I summarise. But I submit the notion that the bank was at fault in not observing such physical differences as there were between the specimen signature and the signature on the wire transfer form it is a hopeless allegation. It should not have been made because no one even looked at the specimen signature in the bank's possession. But anyway, there's no suggestion that such differences as there were observable to the reasonably prudent banker. So that is not a fair criticism. And I say with respect, the courts below plainly erred in saying that was a criticism of the bank. The second point I want to address on the facts in particular is what I call the Gmail point. And the point is dealt with by the judge. And again, forgive me if I've got the wrong reference, but I think perhaps I can take the point from the Court of Appeal's judgment, which is at paragraph 110. But the judge makes a similar point.
Mr. Knox, before you go there, you made the point that the Court of Appeal agreed with the trial judge on the issue of the visible differences then on the signature.
Yes.
On what basis did they do that if such was the submission before them that you're now making to us?
Well, Your Honor, I'm not entirely sure, but I don't think it was ever. I think it's always been accepted that the handwriting experts said there were differences. What has never been accepted, as I understand it, is that the bank itself should have noticed those differences when it was inspecting the document. Your Honor, I don't, as I understand it, understand my clients ever conceded that the bank ought to have noticed the differences. In other words, differences there were, but there was no proper allegation at first instance, no proper putting to Miss Villanueva that she should have spotted the differences. And that's the crucial point I want to make. Your Honour, perhaps when I'm off my feet, so to speak, I can just check that point. But it's a point we make in our written submissions. There was no basis for that criticism.
Just clarify to me then, Mr. Knox, what was the concession you mentioned just briefly before? Oh,
the concession I make is that the handwriting expert's evidence was correct in the sense that there were differences, but such that the handwriting expert could see. Of course, it doesn't follow from that. Could see, having done an expert analysis, that's one thing. It's a very different thing to say that the ordinary bank official also should see such differences. And I do submit this. If you're going to say to Miss Villanueva, if you're going to allege that Miss Villanueva should have spotted them, you've got to put that point to her. You didn't check the signatures properly, did you? Your Honours, I think I'm right in saying that point wasn't even put to her. And then the second thing you'd say is, look at the differences, surely you can see them. And then she'd be entitled to say, well, there's no way I could do that. And that would all be before the judge and he could see her demeanour and things like that. But I do submit that the signature point confuses two different things. One is, was there a difference? The second is, was this difference observable by the ordinary prudent bank official? And on the latter point, there was no evidence and no basis for that finding.
Having accepted that there was a difference.
Yes.
In the signatures, are you also accepting that the signature on the wire transfer form was not that of the client?
Yes, I am. Oh, yes,
okay.
Your Honour, forgive me, I should have made that plain. Absolutely. Yes, we're not seeking to go behind that.
Okay, thank you.
I just wanted to move on to what I call the Gmail point.
Yeah, I know, Mr. Knox, yes. I know you want to move on. Just very, very briefly, if you could.
Yes, Yes, of course.
Just for my own benefit, where in the Court of Appeal judgment, apart from agreeing with the judge, do they deal with this issue that you have just raised and say why they do not agree with it?
Oh, the Court of Appeal. Well, Your Honour, I think it's a paragraphs 38 to 39 of the Court of Appeal's judgment that they deal with the handwriting expert point. (38 to 39). And you'll see in paragraph 38, towards the end, they say the verification method used by Caye Bank wasn't reasonable, as there were visible differences between Connor's signature was on the signature card and the signature on the wire transfer. Well, Your Honour, that I submit is just a non sequitur. I've shown you the I've shown you the difference between the specimen signature, which the bank had, and the signature on the wire transfer form. And I do respectfully submit it's a very rich thing to say that a bank official should have seen any difference between those two things. And the Court of Appeal just say there were differences, therefore you were negligent, effectively. Well, that's just not the case. There are differences, but should the bank official have spotted them? There was no allegation to that effect at all. Not put to Ms. Villanova. So I do respectfully submit the Court of Appeal has gone wrong in coming to that conclusion.
But the Court of Appeal said there were visible differences between Connor's signature, which is on the signature card, and the signature on the wire transfer form.
There was no evidence of that because there was simply no comparison. I mean, the odd thing, it is pretty remarkable, but the odd thing about this case is that the specimen on the form was not compared, sorry, the specimen in the bank's possession was not compared with the signature on the wire transfer. So the whole case was hopeless. But then one has the other point that in any event,
was there an objection taken? I'm sorry, Mr. Knox, for interrupting, but was there an objection taken on that point?
Well, as I understand it, it certainly was objected in the courts below that the bank should have spotted. The bank.
No. Sorry, I meant the fact that the signature specimen in the possession of the bank was not used as a point of reference for comparing the signatures.
I'm not able to say. I can't say that it was taken, but the simple fact is whether or not it was, even if one assumes against me it wasn't taken, the point remains a valid point. And even if one ignores that point altogether, there's no basis in my submission for saying that the signature on the wire transfer form had any visible differences from the specimen signatures the expert did investigate. They're all pretty similar to the naked eye.
Yep, understood.
To the non-expert. And I do submit there's obviously a very important distinction between what an expert can see, having done a microscopic analysis, and what the normal bank official can see without that benefit. And it is perhaps worth bearing in mind one point. On a wire transfer, you don't see the original, you just see a copy. So again, it's not going to be particularly clear in any event. And I did show the differences a moment ago at 148 and I think to 147, 149. And I do respectfully submit the average person would say, looks all right to me. And there's nothing that stands out as an unusual difference. And the expert's conclusion at 454 is essentially accepts that the general characteristics are the same, but there's individual characteristics that are different.
Okay, thank you.
So that's what we say about the visible differences on the signature. We say that's not a basis for holding the bank negligent. Now, I accept immediately that is not the end of the story, because there are other criticisms made of the bank. But an important criticism made is what I call the Gmail point, which the Court of Appeal, I think I'm right in saying, deals with at paragraph 110. You'll see in relation to the unauthorised email address, Mr. Roach has testified that the wire confirmation was emailed to the bank first, and then he clarified the communication was sent to Jason at Rosemore jason1rosemore@gmail.com. And then the court goes on to say that effectively he couldn't say how the email was received. And then towards the end, Mr. Roach has admitted during cross-examination that the Gmail address is an insecure of communication. If the bank had exercised reasonable care and skill, it would have observed the unauthorised email address used by the fraudster. And I think the judge's judgment at paragraph 102C, I think it's at 102C, makes the same type of criticism. I think I may be wrong whether it's 102C, but the judge essentially makes the same criticism about the Gmail point. Forgive me, Your Honours, I think my problem is that I have just want to check this, just checking where one sees the reference to the Gmail point in the judge's judgment at first instance. I had my note at 102, paragraph 102, but I think that must be wrong. It may be, it's at page 102, forgive me, page 102. 102C. One of the criticisms is taking no steps to verify the email address once it was provided to Caye Bank. So that's the judge's criticism. Now, I do just want, by reference, if I may, to the note, just to explain why that again is just a bad point. The reason, and put shortly, I'm on paragraph 7 of the speaking note. The reason the bank sent a confirmation to the Gmail address is because that is what it was asked to do by the admin@rosemore.com email, which came through the online banking portal. In other words, the reason for sending a confirmation to the Gmail address was because they got a proper request, if I can put it that way, through the admin@rosemore.com portal and through the banking portal. And at page 4, Your Honours, I explained the sequence by which everything happened. And it is important in viewing this case, all this is in the documents, just to see the sequence. And I hope for the moment it can be taken that I've summarised accurately the sequence of events by reference to the emails. And you'll see it on the 22nd of April at 11:21 a.m. The bank receives an email from admin@rosemore.com, low priority security message. That's something coming in through the online banking portal. And then that email in turn, and I just want to emphasize this, that is the email that contains the wire instructions, which you see at page 188 to 189. And those are the wire instructions that are the center of this case. So the bank gets something through the online portal at 11:21 a.m. with the wire, which in turn contains the wire instructions, but it gets it with an admin@rosemore.com email address. Ms. Villanueva then reviews the message, and I've taken to that. And then at 1:23 p.m. on the same day, an email from admin@rosemore.com to Ms. Graniel at the bank says, "I'm only reminding you I'm traveling and only have access to my personal email." So here's the fraudster writing from Rosemore's proper email address saying, "I'm traveling and only have access to my personal email. Kindly send confirmation to that one. And when I received, I will call back." And that's attached to Mr. Roach's statement. And then at 10:11 on the next day, 23rd of April, Ms. Graniel, that's at the bank, sends a low priority security message back to the admin@rosemore.com saying, and that in turn contains the message saying your wire request will be processed today. And confirmation will be sent to your, i.e. Gmail, personal Gmail, because safe travels it should be. In other words, she's writing back to admin@rosemore.com, which is a perfectly proper email address, saying, because you're traveling, I will confirm later and send to your personal address. And then Mr. Connor accepts he did receive this email as it was automatically transferred to his own jconnor@rosemore.com email, and I give him the references. So that's what you might call the genesis of the Gmail story. And then over the pay, and then at subparagraph 6 Ms. Granule then sends a message to the Gmail address, what you might call the totally bogus address. Kindly see the wire confirmation. In other words, it's already gone through. And then, I say Connor, but the bogus Gmail address in subparagraph 7 says, thank you, Ms. Granule, I'll give you a call. Now, I submit there was nothing wrong with sending a confirmation to a Gmail address, given that's what the proper email address had asked to be done. Nothing wrong with that at all. And I just want to, in paragraph 9, I just explain why the Rosemore.com account was one that was given to the bank by the claimant originally, especially to admin at Rosemore.com. We give the references and the judge accepts that. And that was a secure account which only the claimant could use and which third parties couldn't create. And that's Mr. Connor's own evidence, and we give the reference. And we say for that reason, the bank was entitled to send the confirmation to the Gmail account because the request to do so had come from a secure account.
Counsel.
Sorry?
Counsel, I'm sorry. But
yes.
Doesn't admin at rosemore.com travel with the traveler? Even if he's traveling, wouldn't he be able to access that email account?
Well,
wherever in the world he is? Hello. Whether the point was taken or not, you're arguing that the at gmail.com
yes
was contained within an email from admin at rosemore.com.
Yes, I am. Yes.
Now, shouldn't this have sent off alarm in the bank? Why would you think that you could not access emails addressed to admin at rosemore.com wherever in the world you are?
Well,
I'm not certain about that.
Well, Your Honour, maybe or maybe not. That wasn't actually put, of course. But even so, I submit if a customer says to you, please, from an authorised and proper email address, please, I'm travelling, please send it to my other address, then in my submission, you're perfectly entitled to do that. A, obviously entitled in one sense, but B, it doesn't, in my submission, give rise to any alarm bells because, for the simple reason, if he's sending it from at the proper address, you can be assured that it's a proper request.
But Counsel, the agreement between the bank and the respondent is that these two accounts email accounts would be the accounts which would be used, the Rosemore or the Connor at Rosemore.
Yes, I agree. Those are the agreed ones, but they're dealing with Mr. Sorry.
And if I may, in an age where cyber fraud is rampant, wasn't this cause for some kind of inquiry on the part of the bank? I'm not certain.
Your Honour, I say no. If you've got a I agree if it had come from some other source, I would agree with you. But if it's coming from what you might call a totally kosher source, and it's the signature, it's Mr. Connor himself who appears to be saying this, then in my from the admin email, I submit you're perfectly entitled. You're not put on inquiry just by that alone. Because this is a secure email address, you're being told to do it from, and the authorised email address. But Your Honour, I can see the room for argument, but in my submission, to say that the bank should be put on inquiry by that alone, I submit would be taking it too far.
Thank you.
But you would agree that that is one of the elements that might send up a red flag in the circumstances.
I wouldn't agree that it would send up a red flag in circumstances where the request to do that is coming from a perfectly proper address.
No.
And there's an explanation. And there's an explanation. I'm travelling. Would you mind using my Gmail address? And it's not totally unknown, I would have thought, for work addresses not to be easily transportable when you're travelling. People often use different addresses. Now, of course, it was a bogus excuse.
Exactly.
I
exactly
accept
the
it's
point.
a bogus excuse.
Exactly. My own experience, Counsel, is that very often the bank will agree ahead of time the email addresses to which they will direct this kind of confidential communication. And anything which varies those agreed parameters would be the cause of some concern on the part of the bank, which may very well lead them to calling me on the telephone to make sure that the variation in the instructions is authentic.
Your Honour, can I just come? I will come back to that point in a moment. I want to just finish my submission, then I will deal with why I say it was not of itself sufficient to raise a red flag. Of course, I see the point that's being made, but I do just want to make one or two other points before I get to that, because I submit one has to look at this in the round. You have to look at as well all the facts, and in particular all the facts known to the bank to understand its conduct.
Sure.
And I accept you might say, well, that may be equivalent. Can I just say why I say it was reasonable for the bank not to be too concerned about the Gmail, what I call the Gmail request. First, as I've said, it came from a rosemore.com account, a safe account and so forth. Second, the request, the original request for the monies to be transferred came through the bank's online portal, not just by email. And this is an important point, only Mr. Connor would have known the password to get onto that account. It is an account which required a password to get into, and a password created only by Mr. Connor and known only to Mr. Connor or such people as he decided to share it with. Can I just mention this? I'm looking at paragraph 10, I think I'm right in saying 10A of the speaking note.
Are you suggesting that Mr. Connor shared the password with the fraudster?
No, certainly not. But what
so
we are,
the premises you're putting forward then can't be correct.
No,
because you are saying that it's only Mr. Connor who could have known.
Well,
and the facts have disproven that, haven't they?
Well, no. In my respectful submission, no. On the face of it, only Mr. Connor would have known, unless for some reason someone has managed to obtain it from him. That is the point. And I do just want to underline this, because it is important, because what we're looking at here is not so much the question of was this an authorised transfer. I'm not disputing that. But how would things have seemed to the bank when deciding whether to act on it? That's the crucial question. And I just want to make 3 points, which we make in paragraph 10A to C. The first is that Ms. Villanueva's unchallenged written evidence was that Mr. Connor would have been provided with 2 temporary passwords when the account was set up for him to change and put in his own passwords, and that only he would know those passwords. It's just like each of ours, it's just like anyone else's online account. I mean, I don't tell my password to anyone, but only I know it. Well, we never know actually, but you're always told not to. But anyway, you don't. So therefore there is a secret secret password, and it's coming through the online portal. So it's coming through what you might call a secret password protected source. And then in subparagraph B, we set out the relevant documents where the bank basically write to Mr. Connor saying, here are you must create here are temporary passwords, you must create your own password. And then Mr. Connor, in his oral evidence cross-examination, accepted that if he'd been asked, if he was requested to do so, he would have created his own passwords. So we say, this is a very important point, the bank has got, on the face of it, a request coming through the online portal, which can only be operated by the person who's got a secret password, and it's coming through on a rosemore.com email. And in those circumstances, I submit the bank was perfectly entitled to say, this is an absolutely secure communication. That's what we say is the short point. And I just now want to come to the terms of the agreement. I accept
just before you do that, could I just ask you, based on what you said, are you saying to us then that if the same facts were to occur again, the bank would operate in the same way?
Probably not. Once bitten, twice shy, but also, well, one has to. I mean, we all learn by experience, and no doubt the bank. I don't know if they have, but no doubt the bank will have tightened up its procedures. But the question is, bearing in mind the obligations it did take on under the agreement, was it under a duty to go further? Bearing in mind, on the face of it, the complete security of the transfer request. As I say, it was entitled to say, looks like a completely secure request to me. I don't therefore have to make further inquiries. Now, I'm just going to come to clause 14. I'm conscious of the time, but I think I'm going to spend my time basically on the proper construction of clause 14 and the exclusion clause at clause 51. And we say probably the clearest of the many unclear versions of the terms and conditions is at 125, and I'll be corrected by Ms. Banner if I'm wrong and there's a clearer version, but 125 is probably the best place to go in the record. Starts at 125, and I just want to draw your attention to clause 2. The bank may rely upon any signature in the payment of funds, signature card and payment of funds. And then clause 8 at page 125 deals with what you might call standard withdrawals. And you'll note withdrawals may be made by written order on forms approved by bank when signed. So there's a specific limitation there. They have to be signed by any one account holder. And then it explains how the funding, how the system is then to work. And then you have, before going to 14, 21D and E, which deals with, I think I'm right in saying is at page 127, no, 126. Accounts of corporations, associations and partnerships. And then if account holders, a corporation and so forth, offering their signature to the signature card represents and warrants and agrees. And then D, dropping down to D, that the bank shall have no duty, responsibility or duty to monitor such an account or the use of funds paid from it, nor any liability for any act or omission by any person who signs the signature card. So let's say there was a dodgy director who signed it, the bank would be exonerated. I accept we're not in that position. And then E, that upon account holder's request, bank may honour items bearing or purporting to bear reproductions or facsimile signatures or authorised signatories on the account. Account holder assumes all risks and responsibilities for such procedure, including but not limited to the risk that the facsimile signature may be affixed by an unauthorised individual, or the risk that the facsimile signature may not be genuine. Now that I agree doesn't get at my client entirely off the hook, but I do submit it's an important part of the background to construing what is meant by clause 14, which one sees at 125. Account holder may, upon verification of signature, or upon identification satisfactory to the bank, authorise wire transfers to and from the account. All outgoing wire transfers must be from accounts on which the account holder is an owner. No third-party requests will be processed. Now, we deal with this in our written submissions, but I just want to make this fundamental point, and I'm on paragraph 13 of the note. This is a permissive clause by which sets out the terms on which the bank is prepared to accept wire transfers to be made instead of normal transfers. It is not, in my submission, purporting to set out preconditions which must be satisfied by the bank before it acts upon such. It is setting out the preconditions upon which the bank is prepared to accept a transfer. And those preconditions are essentially the bank will first of all need to verify the signature, and secondly, it will need to have identification satisfactory to it. And what we say on the facts is quite simply this. There's no doubt that Ms. Villanueva did verify the signature. That is to say, she took steps to verify it. And in my submission, that particular exercise, she can't be said to have carried out without reasonable skill and care, for the reasons I've already given. The second point we say is that the bank obviously was satisfied with the identification provided, but we go further. We say it was reasonably satisfied. I would accept that there's implicitly in that is reasonably satisfied. We can't just say I was satisfied, however negligent I was. I accept that. But we do say, and this is why I took you to the facts earlier on, that in carrying out the tasks which are imposed upon it by clause 14, the bank did not act without reasonable care. First, as I say, it was satisfied with the signature. And second, for the reasons I've elaborated, and which I just want to emphasize a little bit more in a moment, the identification the bank did carry out through Ms. Villanueva in all the circumstances was perfectly reasonable. Now, what is said is, against me, the bank was under a positive duty to do more. And in particular, and this is the sting of the allegation against my client, is it should have made a call back to Mr. Connor on a given number, as in the cards, on the 23rd of April because of the size of the transaction. That essentially is what it comes down to. You should have checked with him first before paying the money out. Now, I say no, not given these terms and not given the realities of the banking world. First, and it's a point that's often made in these types of cases, but very important, the bank's primary obligation is to act swiftly on the transfer. It's simply to execute it. Second, it received, as I've said, the request, and as the judge found, through the online banking portal, to which only Rosemore knew the passwords. Further, 3, the request came from the admin@rosemore.com address, which Mr. Connor himself accepted was a secure address, which no one else could create. And this, my lords, is a very important point, and the judge himself found it, there's no doubt about it. The bank did send to Mr. Connor an email at 10 o'clock or thereabouts on the 23rd of April, which is the low priority email, if I can call it that, to admin@rosemore.com. So in other words, to a perfectly proper address, telling him that his wire process would be processed today and that confirmation would be sent later. So in other words, the bank does write back. It actually gets back in touch with Mr. Connor. But
you know, Mr. Knox,
yes, of course.
I fully accept that the bank got back in touch with Mr. Connor, but the difficulty is the mode of that communication. So you're saying that there's no obligation to make the call,
no, on
the one hand, but on the other hand, you're saying, well, we did make or attempt to make contact through the email system. But surely,
yes,
as weighed against each other, calling is that much more efficient than sending an email which may or may not be seen by the intended recipient?
Well, of course, the bank's case was that did happen, but there was no evidence to the effect it had happened. I think the bank, in the run-up to the litigation, the bank actually said, well, they did make a call back, but that the witness wasn't called. We don't know why. But I say no, is as long as the bank sends an email back to the authorized email address saying we're about to make a wire transaction, that is good enough in all the circumstances. I accept, my lord, but Your Honour, one of the great difficulties with this type of case is, in hindsight, one always says, oh, I wish I'd done that as well. The question is, though, did the bank do what its duty required it to do? And I say it did. It was not under a duty to go further. And the steps it took were those which a reasonable bank could limit itself to taking.
I follow you. Could I just ask one last question before
yes.
I yield to my brother? You spoke about the verification of the signature.
Yes.
And I was very fascinated by that. Are you saying that the bank can verify the signature even if it turns out that the signature wasn't authentic?
Yes. I say, for the purpose of clause 14, what the bank has to do is, quote, verify, that's to say, take reasonable steps to verify the signature. It's not undertaking an absolute obligation that if it does take reasonable steps to do so, but it so happens to get it wrong, that therefore it is liable or not caught by clause 14.
You would understand, though, that many people would take the notion of the verification of the signature as meaning establishing the authenticity of the signature.
Well, again, we say that is exactly what we did do, but it turned out we were wrong. My submission is this, that as long as the bank takes reasonable care over the verification of the signature, it's entitled to say, I've done what I had to do under clause 14. Its duties were, in other words, to take reasonable care to verify, as opposed to an absolute liability in case its verification turns out to be wrong.
As a dominant Well, sorry, I yield to my brother, Justice Burgess. I know I kept him from asking this question. I'm sorry.
No, not at all.
No, actually, it's not a substantial question. It's just to find out from counsel whether he is accepting that clause 14 imposed a duty on the bank to exercise reasonable care and skill in verifying the authenticity of the signature.
Yes.
I just wanted to ascertain whether you accept that is a obligation on the bank, even though it is not expressly stated in clause 14, that it is implicit in clause 14 that had to be done.
Yes, I accept that. Reasonable steps had to be taken to verify. As long as you take reasonable steps to verify, and Ms. Villanueva says she compared the two signatures, then I submit you've performed your duty.
Yes, quite apart from the facts, it's a question of interpretation which I wanted to ascertain. Thanks very much.
Exactly, I do accept that. And also, I should say,
yes. One question, because I think you said that it was not part of the duty of the bank to really call Mr. Connor back.
Yes, in the circumstances.
But apparently the bank thought that was necessary, at least in the person of Ms. Villanueva,
yes,
who instructed Ms. Graniel to speak to the client by phone. Now, apparently it was said that happened, but there is no evidence, so we have to assume that it didn't happen. So apparently, at least Ms. Villanueva was a crucial person in this whole issue, who is part of the bank. She thought it necessary to instruct Ms. Graniel to call back.
Yes, I accept it.
Yes, so then, but you are saying actually that was not necessary. It was not necessarily a duty of the bank.
Not a duty. That's my point.
Okay. Thank you.
Your Honours, I'm conscious of the time. If I may, you have the gist of my submissions on this.
Yes.
And I do submit. It's open to you to review this again, because the Court of Appeal did make in my submission 2 errors, and the first instance judge too, in relation to what I call the signature point. They assumed that mere failure to spot the differences in the signature equals negligence. In my submission, that's not a fair allegation, indeed hopeless. The second point is they don't understand the Gmail sequence. I take Your Honour, Mr. Justice Burgess's point that perhaps there's a different way in which one could put it, but I submit that's pushing it too far. You're entitled to rely on emails from a rosemore.com address. Your Honours, there's just one other point, and that is I accept that $175,000 is a reasonably large sum of money, but it's not $20 million, and it's not necessarily the sort of sum which one would say, in all the circumstances, simply has to be confirmed with the customer. I would like to move to clause 51.
But how does that sum compare with previous withdrawals from the account?
Well, you're right, Your Honour. There were hardly any. I think it was only one of about $1,000 odd. But in one sense, there was no pattern. But if I may, I'm just conscious of running out of time. Move to clause 51, because I submit this is a clear, and I submit very.
Sorry, Mr. Knox, I know you want to get on to 51.
Yes, of course.
But since I have not engaged you at all, perhaps you would facilitate me.
Of course.
By telling me how you deal with the statement made by Mr. Isles.
Yes.
At, I think, 464 about all of the other things which the bank did not do, which he says a reasonably prudent banker would have done. I don't need you to go through all of them. I just want to know what is your take as regards Mr. Isles' statement as to what else should have been done.
What I say is this: Mr. Isles doesn't take into account the 2 most important facts about this transfer. One is it came through the online portal, which was protected by secret password, known only to Mr. Connor. And that, I submit, is a fundamental point. Secondly, it doesn't take into account the fact it came from a secure email address, rosemore.com email address. And those, so one can always make criticisms of what a bank does. You say you didn't do enough, but you've got to start from what was the actual position on the ground which the bank was entitled to take as read. It's a bit like...
You have answered me.
There it is. You have
can go on to 51. Thank you.
51, I submit, is simply unanswerable. If I may, I know that's a red rag to a bull, actually. So I won't say unanswerable because I'm inviting answers. But it's at page 129. It's probably the best copy. And it's under the heading indemnities, and it's B that one has to look at. Your Honours, did you have that? 51B. The bank shall not be liable to account holder for any action taken or not taken by it under the terms of this document, unless directly caused by the bank's gross negligence or willful misconduct. Now, there are just a few preliminary points I want to make on the facts, and I'm on paragraph 22 of my note. On the facts, the judge held there was no gross negligence. He was specifically invited to hold that, and of course it was pleaded and so forth. No doubt because the respondent recognised this was a point that really had to be dealt with. But the judge rejects that at paragraph, I think I've given the wrong page number, but it's at paragraph 210. Sorry, paragraph 105. Paragraph 105. He says no gross negligence, and the Court of Appeal agrees at paragraph 106. So this is a case where the facts are found in both cases as no gross negligence. Second, I'm on paragraph 23. There's no reason to contort the natural meaning of these words. And we all know that exclusion clauses often get read down so as to pretty well become meaningless. But I just make 3 points on that. This is, first of all, this is a contract between two commercial entities well able to look after themselves. Therefore, don't contort the meaning of the words. And we give a reference to Lord Diplock's speech in Photo Productions, where he draws the contrast between the court's approach to consumer contracts and big bad business contracts. We say, same here, you can't just twist the words to mean something they don't. You're dealing with grown-ups in the big bad world of business. Second, and I do submit this is an important point, the imposition of a general liability and negligence short of gross negligence, especially of the you should have made more inquiries type, puts a bank in a difficult position, given that its primary duty is always to act swiftly and immediately on a client's instructions. It's not unreasonable for a bank to say, no, I'll be liable for gross negligence, but I don't want to find myself liable for an error or for doing something wrong, which in hindsight I shouldn't have done.
Counsel,
yes.
Counsel, I think it's, for me, I'd like to know whether the duty which you admitted existed on the duty of care which existed on the clause 14, whether that relates to common law negligence, or is it born out of the relationship of agency between bank and customer? The Quincy care duty, is that a common law duty, or is that a fiduciary duty?
Well, a contractual duty. I'd accept as an implied contractual duty.
Implied contractual duty, and different, and very different from the negligence, general negligence duty.
Well, I would say that as far as that is concerned, in this type of case, banking cases, and the solicitor's negligence cases and things like that, the duties set out by the contract are the same as the duties set out at common law. There's no such thing, in other words, as common law duty being wider than the contractual duty. The two are coterminous.
I'm sorry, Counsel. The question is not whether it's wider or narrower.
Yes.
The question is, what is the source of the duty? Because you're inviting us to look at clause 51.
Yes.
And what you're suggesting to us is an exception clause or an exclusion, whatever you want to call it. Now, the question I'm raising with you is, what liability is that exempting? What liability is that covering? Isn't that covering common law?
Yes.
Negligence?
Certainly. Yes.
If it isn't covering common law negligence, does it suffice to deal with negligence, well, the duty of care, which exists under clause 14? Would it exempt liability in relation to clause 14?
Yes, certainly. It's a general exemption for any breach of duty which falls short of gross negligence.
Yes.
In other words, for any breach of any negligence which falls short of gross negligence, any contractual negligence which falls short of that, and any common law negligence which falls short of that.
I was discussing this with my colleague this morning, and he reminded me of the court's approach to negligence.
Yes.
You remember Thornton and the parking lane case.
Yes.
Where
yes.
Lord Denning said, you know, that you'd have to have a red hand. It should be written in red with a red hand. Now, the court's approach to negligence exemption is that it has to be specific. So if you are going to be relying on clause 51, it seems to me that you would have to exempt liability under clause 14. It seems to me that you are going to have to show that the implied duty, contractual duty under clause 14, which you admitted exists, is the same as general, not the same as, but is based on the general law in respect of negligence, tortious negligence.
Well, in my submission, the position is this, that I accept there is an implied contractual duty on the bank, not just in relation to clause 14, but generally in the performance of its functions, save to the extent that duty is expressly.
Sorry, let's stay with clause 14.
Yes,
it may extend to other duties as well, but let's stay with clause 14 because that's what concerns us in this case.
Yes. Well, in my submission, let us say the clause 51, in my submission, the words are absolutely clear. The parking lane authorities are not in point. The most important authority is photo productions and security calls, or House of Lords decision, which makes it absolutely plain that you look at the words themselves. And I respectfully submit the words of 51B wouldn't be clearer. They are obviously intended to exclude liability for negligence generally, unless it rises to the level of gross negligence. And the words, for instance, not liable for any action taken or not taken by it under the terms of this document. It's referring specifically, it's saying if there's anything I do envisaged by this document, which I do negligently, but not grossly negligently, then I am off the hook. That's the intention of this.
Counsel, could you help us to find a case where the courts have ever held that general words can exempt liability for specific instances of negligence?
Well, no. I think,
and for productions, it's not. With respect for productions, it's not such a case.
No, but it talks of the general principle. But in my submission, one doesn't need any particular authority. One just looks at the words themselves.
Except counsel, and I'm sorry to be belaboring the point, but it's important because you're relying on clause 51. Except that all the cases say that you cannot exempt liability for negligence, particular types of negligence, with general words. Well, in a general clause like 51.
My lord, I would respectfully disagree with that. We haven't had any cited to us in the case against us, and we have made our position on this absolutely plain. I'd be very happy to deal with any such cases, but in my submission, there is no general doctrine. Can I start with this first of all? Clause 14 doesn't have an express, as it were. It's all implicit. And what I submit 51B is directed towards is generally any action or inaction taken under this agreement, and can I emphasize this, taken or not taken by it under the terms of this document. It's referring to the terms of the document. And what I submit, and the purpose of that is to say, in other words, anything which I've done, which is envisaged by this document, which would obviously cover 14, I'm not liable for, unless there's been gross negligence. Then, of course, there is. So it's not a complete exclusion. It's just an exclusion for anything save gross negligence. I submit that's perfectly understandable.
Counsel, the banks are served by excellent commercial lawyers and contractors. Why wasn't clause 14 made subject to section 51. Why that wasn't clause 14 written subject to section 51 and so on?
Well, because otherwise you'd be having to put that in every single clause. If I know that may sound facetious, but but I say clause 51. Now I accept your lordship's point, but I say clause 51. You just look at the words there. It's clear. There's no liability to cut and so forth. So I say the words are wide enough and expressed in general enough terms to cover any form of negligence, and that I submit as an end of it. One may say, oh, that's not very attractive. Where's the red flag? And what about red underlining? Well, maybe. But we're dealing with contracts between commercial people. And I submit one mustn't contort the meaning of this, because the trouble, but I submit that it's difficult when, and this is an important case, because the court will be setting a precedent across the Caribbean and across the common law world as to how to interpret, on the face of it, wide provisions excluding for gross negligence, everything except gross negligence. And we do make the point in our written submission, but it's referred to, I'm conscious of the time, so I don't want to belabor the point too much. But
I don't think that the chairman has been breathing down your neck for the time, Council. We are enjoying your presentation very, very much. The point you're making just now about the common law world and how it reacts to this case is fascinating. Are you saying that in your experience, we have not had too many cases like this one in the common law world?
Well, I'm not sure how many there are. There is a case which my learned friend refers to. I think it's one of her authorities, and she's helpfully drawn it to the tribunal's attention in support of her case. But there is a point which I say, as is often the case, something in it for everyone. This was another banking case where a bank had put in a similar exclusion clause, not liable for anything except gross negligence. Now, it went up to the Court of Appeal in England on a strikeout, but it was conceded for the purpose of the strikeout by the customer, if I can call him that, that this clause could exclude liability. A clause excluding liability, save in the case of gross negligence, could work. Now, as far as I'm aware, there's no actual authority in the banking world which deals with a clause which I apprehend may not be uncommon at all, where banks say, I'm not liable for anything except gross negligence. The name of the case, if I may just refer to it, is, I think my learned friend refers to it, is J.P. Morgan Chase Bank and Federal Republic of Nigeria, paragraphs 24 and 45. That was another case of the bank putting in a similar clause. And that's why I say it is actually of some importance what your lordship say on this point. You may not think it's a very attractive point, but my answer to that is commercial contracts aren't beauty contests. They are tough old things. And banks need to limit their risks. You
say that if it's construed against you very narrowly, then it robs the exemption clause of any content.
Yes,
but surely the other side is saying, well, all you have to do really is make the phone call. If you make a call, then you are basically off the hook. But the problem here is that the bank did not take the opportunity to communicate directly with the account holder.
That's true. That's true, but that doesn't, and we have two findings of the courts below, that does not equate to gross negligence. And I submit that that's unchallengeable, and it hasn't been challenged in this appeal. And we've taken the point squarely in our note, our written case. I accept that I am what you might call running the line between saying I'm negligent, but I'm not liable because I'm not grossly negligent. But that is, I say, that's what the contract says, and we have the findings of fact below to support us. And I do say it's an important point, generally. And I obviously, one as a human at a human level feels, well, I don't really like this, as it were. But on the other hand, this is a perfectly understandable thing for the bank to put in, and I say the words are clear. Not liable for any action or inaction taken under the terms of this document. Now, can I just say this? It has to be inaction or action taken under the terms of this document. So supposing what had happened is the bank had acted on a scrap of paper. Now, that's not envisaged anywhere in this document. Supposing the bank had acted on some oral instruction. You might say, well, there's no way that that's not acting under the terms of the document at all. But in this case, the bank was undoubtedly acting under the terms of the document. It just got it wrong and wasn't careful enough. So that's what this. I don't want to go on too long, but that's the strength of it. You must give this clause some content. It's a tough clause, but it's a clear clause, and we have the financial facts to know. Yes,
Mr. Knox, doesn't honor the terms mean in accordance with, which is to say, it must be an authorized signature, an authorized withdrawal?
Well, in my submission, not, because again, that would deprive, and of course that is what's said against me. In my submission, that would deprive the clause of all effect, because
with respect, I saw that in the written submissions, but I don't see why. Because no, let me just make this point. The same JP Morgan case you mentioned.
Yes.
A bank can receive a valid authorization, an authorized instruction, but the bank, as Queen's Caye and JP Morgan indicated, could be put on inquiry and therefore should not act under the terms of the depository agreement. And in that situation, one can see where the absence of gross negligence can operate, because it is a valid instruction. But where you have a situation where the instruction is a forgery, then is that under the terms?
In my submission, yes. I see the distinction drawn by your lordship, Your Honour, essentially, is the distinction between acting on a valid authorisation when you shouldn't have done, and acting on an invalid one. And therefore, the question is, does this cover acting under an invalid instruction, as opposed to acting under what is on the face of it a valid instruction? In my submission, that's just not what the words mean. Under the terms of this document does not mean in accordance with this document, or it simply means under the terms of. And I do submit that it's difficult to see why there should in fact be a distinction between the two cases which Your Honour has put to me. If, let us say, what happens is, let's say there's a dodgy director, and he's the sole signature on an account, and he writes out a check to please pay my personal gambling account at Genting Casinos, then of course it might be said he's got authority to write that check out or to give the instruction. But the bank should realise, under its Queen's Caye duty, that he's up to no good and should make inquiries. That's the classic Queen's Caye duty. In other words, authorised signatory asking the bank to do something which the bank ought to realise is simply wrong. But in my submission, that is difficult to see why the fact that there's an authorised signatory asking the bank to do something which the bank should realise is wrong is in any different position, looking at these words, from someone who appears to have authority and the bank believes to have authority from an email address and so forth. I fully get difficult to see why there's a difference. Sorry. In other words, I can see the difference in fact, but I say it doesn't make any difference on the wording of this contract.
I think we should now be near the end of your presentation. Maybe a few more minutes. We had a lot of interruptions because it is an interesting area, but I think you will be able to finish it within a few minutes.
Oh yes, certainly. I don't. In fact, I think. I mean, in the course of the questioning, I've more or less covered, I think, what I was going to say on clause 51 in any event.
I think so.
You have my points that the common law and contractual duties are coextensive. There's no point saying, and I do say this, if it excludes the contractual duty, save in gross negligence, it must also exclude the common law duty, save in gross negligence. Otherwise, the clause is doing nothing. You can always get around it by resorting to common law. That can't be the intention. There's also this point, and I must address it in fairness to the respondents. Of course, I do accept, although we took this point at first instance, and indeed we appealed on it in the notice of appeal, the point was dropped in the Court of Appeal. So the question arises, well, is it open to me to take the point now? And we've dealt with that in our written submissions, but I deal with that at paragraph 28 of our note. And we simply say we've got the relevant findings of fact. We don't need any more facts to be found. We know what the term says in the contract. And the judge at first instance did deal with it. And the Caribbean Court of Justice and the Second Court of Appeal can, in those circumstances, deal with it as essentially the point I'm raising is a pure point of law on given facts. And we refer, Your Honours, to a case called Caroon, which is a 1993, I think, decision in the Privy Council, which sets out the relevant principles. And at page 1699, you can see those principles. It goes back to the late 19th century. Caroon, the reason we've referred to Caroon is because that was a case where the Privy Council did actually say, I'm going to look at this point, even though it wasn't pursued below. They went on and looked at it and rejected it, but they looked at it all right. And they said it's proper to do so because it was a serious point. We say the same applies here. This is a serious point on undisputed facts, and Your Honours are in as good a position to deal with it as the courts below.
I suppose you want us to look at it, but not follow the second part of that decision and reject it.
Exactly. We certainly do, and I submit it is a very important point. It really is. It's not straightforward, but one is faced with these words.
Yeah.
And I submit not unreasonable for the bank to want to limit its liability in this way. One can see the commercial imperatives which make a bank put this type of clause in. It's not what you might call like one of those crazy parking cases where I say, if you don't move your car by 10:05, you'll pay me £150 or something, or whatever. The final point is the indemnity point. Well, the indemnity is at page 152, and we, of the bundle, I don't think I need really take you to any authority on it. It's page 152. In consideration of your, and I emphasize these words, agreeing to accept instructions from me, us, with earwig on the instruction, and acting on such instructions, we hereby undertake to indemnify you against virtually everything that you may suffer or sustain by reason or on account of you having accepted such instructions. And you'll be entitled to debit our account with the amount of any payments you make in respect of having accepted such instructions. Now, what we say is this: the obvious intention of this is that to give the bank protection in the in consideration of the bank agreeing to take the risk of wire transfers and the like. The bank is protected against any action it takes in so acting on those instructions. And we say, well, that's that. And we'd also say this was a clear term. It's not just stuck away in some conditions. It's clearly there, a separate document, and it's signed by the respondent. And that, we say, means that we're entitled essentially to a cross indemnity in relation to such liability as we would otherwise have. Your Honour, I don't think there's anything else I wanted to say, unless there's a point I haven't covered or you just want to put to me.
Well, I think you've got enough questions today. I don't think, well, if there are any questions at this point, they can be asked, but I think we're fine now. And we can move on to the other side.
I'm obliged to, Your Honour.
Ms. Bennett.
Mr. President.
Yes.
If I may, is it possible for us to take a 5-minute comfort break?
It crossed my mind, and you're right to say so. I think 5-minute break would be good, and then we can listen to Ms. Bennett. So we'll be back. It's now, on my clock, it's 19 past 12. Well, let's take it till 12:30. 12:30, we will be back. And that will be 10:30 for Ms. Bennett.
Thank you. Thank you, members.
We
I'm
have
not seeing Mr. Justice Barrow. Is he, Justice Barrow, are you with us? Are you back with us? Mrs. Barrow, are you there? Thank you, Judge. Court resumes. Thank you.
Okay, Ms. Benner.
Yes, may it please, Your Honor, the court. I would like Your Honors to start by addressing the specific points that were raised by my learned friend. I would like to address those simply because they're fresh in our minds, and then, of course, go back to my initial reply to the response to the Rosemore submissions. And I'd like to start particularly with the Gmail point that was raised by my learned friend. And one of the things that strikes me is that there is an assumption in making the point that there can never be internal fraud in a bank itself, that fraud comes entirely from outside of the bank. And I think starting from that assumption, and I will show how His Honor Justice Anderson queried this issue and why that thinking is flawed. Now, if the court would recall how the issue started with the Gmail, the transaction, this transaction did not start with a request through the NetTeller account. It actually started with a conversation, and that conversation was referenced in an email that was sent to the bank. So if I may draw the court's attention to that conversation, it is at in the record at page 186.
Maybe you can keep your papers a little away from the microphone.
It is loud.
Yeah.
Yes, Your Honor. So there was a conversation that commenced, and then that conversation was referenced in an email through the NetTeller system. And there were two, if I may just draw the court to the email referenced by my learned friend at page 186. It says, "Good morning, I apologize for the late response. I had to leave unexpectedly, etc." And then I'm only reminding you that I am traveling and only have access to my personal email. Kindly send confirmation to that one. And when I receive, I will call the bank. Before this, I will draw the court's attention to that conversation as soon as I'm able to find it. But essentially what occurred here, and the point that I want to make with respect to this issue, what learned counsel is saying is that this email originated through the NetTeller account. And you must assume to accept this argument that the internal bank fraud is not possible. That is what we say. And in this case, there was no evidence before the court that the claimant was the only one that could access that account. In fact, that was the very issue that was referenced by both the Court of Appeal and the Supreme Court, namely that there was no IT expert evidence available to suggest whether or not the bank system had been compromised or Rosemore's system had been compromised. So,
Ms. Barnett, just before you go further, how is the conversation that you mentioned earlier, how is that impact on the case? How is it relevant?
Well, it is relevant because with respect to the communication coming from this person, it all started with a conversation, and then the communication, as shown in the NetTeller system, is presented. So there's no evidence presented by Caye Bank, which showed or which demonstrated what was said in that conversation. We do not know and cannot speculate, of course, what was said, but it is only to make the point that this communication between the bank and this third party did not commence by virtue of the system. It commenced through a conversation that was had with a call, and then the communication continued through the NetTeller system. I will draw your Honor's attention to that shortly.
So that was a conversation between who?
This is the conversation between Graniel, which is the person that was not called, and this third party that contacted the bank, which we would assume is Yaron David Walter, but cannot confirm.
Okay.
So it was a third party. That much has been confirmed?
Yes. That is a factual finding, concurrent finding of fact that Connor had not authorized this transaction and was not implicated in it. And in fact, what Mr. Justice Abel said below is that it is some third party, and likely Yaron David Walter. He did not specifically say it was him. He said likely it was him. He was implicated in it because obviously he received the funds. And the issue, I would like to just drill down on this issue, because if the court would look at paragraph 95 of the Court of Appeals decision at page 32 of the record, now there, the court addresses, pardon me, I think I have the wrong paragraph.
And by the way, that initial conversation that is to be found somewhere, in the record?
Yes, I will attempt to draw it quickly to the court's attention. I had it flagged, but my apparently it fell off. But I just want to go back to this point with respect to the conversation. If I may just quickly find this paragraph. Court of Appeals decision. It says, this is at page 40, Your Honors.
40.
Yes. And at that paragraph, what the court says, the submission of Caye Bank that there was sufficient evidence to show that the invasion was perpetrated on Connor's system was without merit. The issue as to the breach of the security system was a matter that could have been proven by experts in the field of information technology. The banking experts who were brought before the court were not experts in such field and therefore could not prove that the system was breached. Caye Bank's case was focused on proving by its honest belief that the wire transfer was authorized by Connor. So what we say to this court is that it is not correct to say that Connor was the only one that had access to that account. It was never proven before the court that that was the case. In fact, the court expressly mentioned, and in fact, both judges expressed angst at this issue, that no IT expert had been brought in order to demonstrate that in fact it was Connor's system that was breached and not the bank's. There is no evidence before the court, and certainly no IT evidence to demonstrate whose system was affected. So I just thought that it was necessary to bring that to the court's attention. Now, the Gmail point is an extremely important point, and it's one of the more compelling finding of facts, which militates in favor of a ruling that the bank was put on notice insofar as we want to discuss the Queen Square duty later on. And to that end, I'd like to draw the court's attention to I will just mention, I have the page numbers in my speaking note, which I could share with the court afterwards, but the relevant page is 1043 of the transcript, of the record, and that is the transcript of the trial court. And starting at 1043 of the record, you will see cross-examination of Mr. Roches regarding this Gmail point. And if I may just very quickly read a portion of this. Now, being in the banking industry, you're aware that a more secure email is where you have the domain rosemore.com, correct? That's correct. And a gmail.com email is relatively insecure as a form of communication. Isn't that so? Agree. And we go through it, eventually coming to the point, Mr. Roches, there is no evidence before the court of where this email address came from. Is there? No. That's on page 1044. And ultimately at page 1046. So where is the information as to where this came from? And he says, I really can't address that. I really don't know. What struck me, Your Honors, is the statement that my learned friend read from one of the emails where the third party or the person contacting the bank says that he is traveling. I'm only reminding you that I'm traveling and only have access to my personal email. Kindly send confirmation to that one, and when I receive, I will call the bank. Thanks. Obviously, the personal email address had been given already because he saw no need to repeat it here. So we can assume for the purposes of this communication that it had been given already. It is striking because it is similar to what happened in the BA Holdings decision, the BA Holdings and Heritage Bank decision, in which bank fraud was also an issue with respect to a third party infiltrating and having taken over having been wired some funds that belong to the account holder in that case. And the facts from that decision will show, and I'll just reference the paragraph 24, Ana Romero requested the PIC and the person responded by saying that the PIC could not be recalled and that he was traveling at the time. And the reason it strikes me is because the fact that third party contacting the bank is saying that they're traveling, they are immediately putting the bank at ease in terms of, or attempting to put the bank at ease in terms of the manner in which they comply with their duties. I'm rushed, I'm traveling, and I require some assistance. And we say that it's a theme that runs throughout these sorts of fraudulent transactions, the informality of it. The fact that the email address jason1rosemore@gmail.com was given to the bank should have immediately alerted it to the fact that there was something untoward going on in this case. And the reason we say that is because there had been an established mode of communication between the parties, established since 2011, some over 3 years before this transaction occurred. And that established mode was that if you wanted to contact the account holder's agent, Jason Connor, you would communicate by virtue of the rosemore.com domain secure email address. So we say, Your Honors, that was one of the, that was a perfect red flag in the sense that it ought to have immediately alerted the bank to the fact that someone is trying to have us communicate through another means. And my learned friend on the other side argues that, oh, the account was, the details were secure, only Connor knew them. Only Connor knew them, so only Connor would have communicated that, and only Connor would have communicated the Gmail address to the bank. And that communication of the Gmail address came through the NetTeller account. There is no evidence that the Gmail address was given through the NetTeller account. There was a conversation that was held prior to these email communications. 2, to accept the argument that my learned friend makes that, you know, this was a secure account, only Connor had you must assume for that argument that bank fraud, internal bank fraud is not a possibility. And 3, we cannot draw that conclusion because it was not a finding of fact in the courts below. It was not one finding, there was not a finding of that either in the Supreme Court or the Court of Appeal. And both judges were expressed the difficulty in understanding why the bank stopped short of trying to prove that in fact someone else had invaded its account. So the Rochas, in fact, for Caye Bank did in fact admit that Gmail is an insecure sort of communication. The bank knows this. They know it is insecure, and they ought to have seen it as a red flag. Now,
if I may ask, Mr. Knox said that Graniel sent a low priority secure message to admin rosemore.com containing the email message apologizing for the late response. Your wire request will be processed today and confirmation will be sent to your email. Safe travels, Floor. That went to the official email address. He says Connor receives this email. Now, if he received it and he doesn't know anything about a wire request, how do I have to see this?
Well, Your Honor, if I understand Your Honor correctly, what she is saying when she says Connor receives the email is that the account assigned to Connor received the email.
Yes.
So it's Mr. Connor has never, in his evidence, and the court has agreed with him, they've never found that as a fact that he was the one communicating with the bank and did not request this transaction and was not implicated in it. So when my learned friend suggests that Connor received this email, he obviously, I would expect, meant that admin at rosemore.com received this email. But we must recall that this is the bank portal that the information is being shared on. So this is a bank portal. It is not as if it is coming through Outlook, it is coming through the bank's portal. And there has been no evidence presented to the courts below, which would even suggest that the Connor's system was compromised. And that was a clear finding of fact also. There was no evidence to suggest that any of these systems were compromised. The fact is that the bank stopped short of trying to prove that and only relied on genuine belief. And it could not be something that Rosemore would look into, because according to the clear evidence of the bank, the bank only held records for a period of 90 days. No electronic records were presented, which would have permitted Rosemore to hire an IT banking expert and to delve into the security of this system. I hardly think that one can, with a straight face, say that this is impenetrable, this banking system. There has been no proof of that, and there was no attempt to prove that.
Ms. Bannett, going back to what you mentioned at the very start of your submissions to us, at paragraph 61 of the judgment of the High Court judge, is that what you're speaking about? There is a notation. The trial judge states that Ms. Villanueva reviewed the request and testified she was satisfied that it was duly signed and authorized by Rosemore. And among the reasons given there at E, is this what you're speaking about? That she noted that Graniel, the primary verification officer in this transaction, wrote on the request that the client called to confirm the wire and the indemnity password and had affixed her signature. And yet we have at F that Ms. Villanueva instructed Graniel to be sure to speak with the client via telephone confirming the transaction. Could you shed some light on that, or how did that play out both before the trial judge and the Court of Appeal?
Yes, Your Honor. The client called to confirm the wire and the indemnity password on 26th of April. And 22nd of April. Yes, this is the call that we're referring to, because what happened is that the client called the bank, and the purported client, called the bank and made some inquiries. And based on those inquiries that were made, that was when everything was initiated with the net teller banking. The communication started back and forth. And with respect to this notation, the Trisha Villanueva gave evidence that she told Graniel to call back the alleged client to confirm that that was the person, and the evidence she did have in her witness statement that that was done, but that was struck out as hearsay. Graniel was not before the court, and as such, there was no evidence, in fact, that there was a call back to the alleged client.
Just to get your confirmation that this is the conversation that you're speaking of? This is the notation, Ms. Banner?
Your Honor, the notation that I was speaking of is actually contained, sorry, not the notation, the email, what I'm speaking of is an email that was actually sent to the bank. But I will definitely come back to it, Your Honor. I do appreciate that my time is running, so if I may just move to the next point and then come back shortly. With respect to so just to wrap up that Gmail point, the point we're making is that it was a perfect red flag for the bank. The fact that someone is asking you to use an email, which is not the mode of the established mode of communication as per the documents that were filed with the application. Not once before in over 3 years of this his communication with the bank had he used that email, which he called his personal email. And in fact, there were only 2 known emails with the domain rosemore.com. The bank ought to have been, the bank was put on inquiry and ought to have said, you know, this is a new email address, gmail.com. It's not secure. Mr. Connor has never used a regular domain. He has always had his own domain. So let us just call him to make sure. Or let us not send an email through the NetTeller bank system, the portal. Let's send an email directly to him through Outlook and see what he has to say. That was never done, and it ought to have been done because the bank was certainly put on notice. With respect to...
Can you just remind us, please, as to how that point was characterized in the courts below? That is to say, the Gmail point. Was there a finding of negligence, gross negligence in relation to that point?
Yes. Sorry, with respect to the Gmail point, let me just ensure that I draw the court's attention to the correct page. Pardon me, Your Honor.
Yes, but I don't want to distract you too much. We'll take your word for the moment. If you wish to continue, that's fine by me.
Your Honor, thank you, Your Honor, for the time. I just wanted to look at page 102 of the Court of Appeal, of the record.
Yes.
And this is where, the High Court, this is where the Supreme Court said at page 102, this court also considers that based on cross-examination of Dean Roches and the evidence of the banking expert Isles, the latter of which this court found to be both credible and largely applicable, that Caye Bank failed to comply with reasonable and therefore mutually accepted banking standards for the processing of online wire requests. These breaches include the following, and then with respect to B, C, and D, he says, failing to be alerted by the fact that for the first time since opening the account, the email address jason1rosemore@gmail.com was used for the unauthorized transaction, and this was not the email address on record for Rosemore. C, taking no steps to verify the email address jason1rosemore@gmail.com once it was provided to Caye Bank by the third party for the purpose of sending confirmation that the funds had been wired. D, failing to have adequate and reasonable procedures in place to verify the email addresses used by Rosemore. So that is what the Supreme Court said. And the Court of Appeal, if I may just go to that. The court goes through the brief background facts, and that may be found at page 10, where Rosemore identified its email address at admin@rosemore.com. Any emails that were sent to admin@rosemore.com were automatically forwarded to email address jconnor@rosemore.com. Additionally, the bank had his telephone number on record. They reference it again at paragraph 13, which is on page 12 of the record. And on instructions received from jason1rosemore@gmail.com. And then she goes through that point. Her ladyship goes, her honor goes through that point, and says the trial judge, after considering the evidence of Mr. Roches and Mr. Isles, found that Caye Bank failed to comply with reasonable and mutually accepted banking standards for the processing of online wire requests. He found that Caye Bank failed to be alerted that for the first time since opening the account, the email address jason1rosemore@gmail.com had been used for the unauthorized transaction, and this was not the email address on record for Rosemore. Further, Caye Bank took no steps to verify the said email address once it was provided to Caye Bank by the third party for the purpose of sending confirmation that the funds had been wired. Caye Bank gave no evidence as to the manner in which it received the email address of jason1rosemore@gmail.com. The trial judge stated that it was through disclosure of documents that it was shown that the confirmation of the wire transfer was sent by a Caye Bank employee to jason1rosemore@gmail.com, an email address unknown to Connor. And then she goes on, he stated that he received a copy of an email which showed that the unauthorized email had been used for confirmation of the wire transfer. The analysis continues down to page 44 of the record. And then the judge concludes, as such, I am of the opinion that the evidence considered by the trial judge and the conclusion reached by him in relation to the email address was not inadmissible hearsay evidence. So that was the point she concluded on. But all in all, what appears to be clear from the findings of both courts below is that the use of that email address ought to have alerted the bank that something untoward was happening, and that it was a red flag that ought to have been guided them and ought to have triggered their Quint Square duties, which would have been to, one, stop the transaction, something untoward is going on here, and two, make inquiries, proper inquiries through the established modes of communication, not through the bank's own portal, but directly to Mr. Rosemore, Mr. Connor's email address, or by a telephone number, which the court also found was on record.
So you're saying those were the two red flags?
Well, we're saying that that first one, the gmail.com was a big red flag. And we say that because one, it was used for the very first time and brought up for the very first time. Two, conversely to that, at no point during the previous 3.5 or more years had that is a red flag. It's not as if it happened 2 weeks before the transaction, where they get a message from Mr. Connor or from Rosemore.com, the portal, to say, I may want to do a transaction, in future regarding, but sometimes I have better access to my personal email, gmail.com. So I want you to use it. What is the process for me to change that? Do you need to do a call back? Do we need to have a telephone call? That wasn't the case. The use of gmail.com, that email address, arose in the midst of the transaction at issue, wherein over 70% of the funds were being transferred. So we say that, Your Honor, is a very big red flag. It was one that apparently Trisha Villanueva was probably not brought to her attention, but we can only speculate. What we can say was that it was certainly brought to the attention of the bank's officers who were involved in the process that they must engage in when a wire transfer is to be effected. The bank chose not to bring Ms. Graniel to court to explain that. And as such, the inference should be drawn against the bank in terms of why it refused or failed to bring Ms. Graniel to court to explain that. The fact is, the bank's officers had notice of it, and that is why we say Trisha Villanueva's evidence cannot be taken in isolation. It must be looked at in totality, not only one person who was involved in the verification process, but all the officers who were involved in the verification process. In terms, if I may quickly move on to the 21E point that my learned friend raised, in construing that provision, Your Honors, it appears clear, to me at least, that the provision is, I would almost go so far as to say, is not relevant at all. That provision is on page 126 of the record. And when the court reads that provision, it says account holder, accounts of corporations, associations, and partnerships. If account holder is a corporation, association, or partnership, every person affixing their signature to the signature card, represent, warrants, and agrees. The every person there is referencing the signatory, not the account holder. So the umbrella provision for this is referable to that person. And when you look at what follows it, all of it falls under that umbrella provision. So it's totally inapplicable to the account holder. The signatory did not sign this document. They signed an indemnity, and the court dealt with that issue and said that, of course, that indemnity is not applicable because of the way it is to be interpreted. Now, one of the things my learned friend said was that in terms of the bank's obligation, only Rosemore knew the password to the account. Again, we submit that has never been established either on the evidence factually or by any expert in terms of giving opinion evidence as to the accessibility of the net teller system. And to accept the argument that only Rosemore knew the password, you must assume that it is not possible for a break into the bank system, We cannot assume that because there was no evidence of that. I go on to the first point which my learned friend raised, which was the signature. Now, Your Honors, the Court of Appeal said clearly that they do not expect that a bank to have an internal handwriting signature expert on hand. And that is at paragraph 99 of the court's judgment, the Court of Appeal's judgment. And not to belabor the point for the court, but basically what the court said, which is at page 41 of the record, it should, in the middle of paragraph 99, it should be noted that the handwriting expert confirmed that a review of the wire form with the naked eye clearly demonstrates that there was an outstanding difference between the signature of the fraudster and Connor's signature. So that is what the handwriting expert found, and the court below found that witness to be credible. And the conclusion by Caye Bank that the signature was an accurate representation of Jason Connor's signature, as discussed before, was an error. It was not Connor's signature as found by the trial judge. The wire request was for $175, which is a substantial amount, and there were red flags which the bank should have queried and failed to do so. With respect to that point, it goes back, Your Honors, to what the court was saying in Absa Bank, which is that if the bank will accept merely a signature, an electronic signature of that, not an original one, then the bank is responsible for the type of signature that it decides that it is going to accept. And I've summarized that very briefly, but of course it's much more refined in Absa Bank, where it says that it is the bank's responsibility if that mode of giving instructions enables a dishonest individual to perpetrate a fraud. The bank cannot lay blame for the fraud at the door of the customer when the customer did what the bank had conveyed was acceptable to it as a means of giving it payment instructions. So what we say, Your Honors, is when the bank was put on inquiry, what happened is that it had a duty to stop the transaction and proceed with making the appropriate inquiries. And what we say in that regard, with respect to the possible visible inconsistencies that were referenced, and the reason I bring this up is because my learned friend had referenced this issue that the court found that there was negligence because of the failure to find these inconsistencies, but that is a mischaracterization of what the court said. What the court actually said is at page 30. The judge listed over 12 breaches, and this is at paragraph 64, page 30 of the record. The judge listed over 12 breaches, which include that there was no call made to Connor, failure to ensure that the communication regarding the wire transfer was only with Rosemore's secure domain name, rosemore.com, and not with the low security public domain gmail.com, failure to properly inspect wire transfer request form and to observe possible visible inconsistencies in the signature on the form, failure to notice that, etc., etc. What we say, Your Honors, is that of course there's no obligation on the bank to have a handwriting expert on hand. What the bank was required to establish is that it took the steps that were necessary to verify the signature. If the bank is saying itself that this is an insecure receipt, it had exercised reasonable care. So I will also reference Court of Appeal, page 36 of the records, just for Your Honors to review that point. And I want to move on again to the
So the question is if the bank was negligent, if the bank failed on several of these points. Was the bank negligent?
Your Honor, the evidence demonstrates that, well, on the pleading, there was a pleading that the bank was negligent, and the evidence demonstrates the concurrent findings of fact of the courts below demonstrate that the bank was in fact negligent in the way it conducted this exercise. And the evidence is supported by the expert Marvin Isles as to what ought to have been done, but also by the steps that were actually taken by the bank. And that is addressed in the Court of Appeals decision, as well as in His Lordship, Mr. Justice Abel's decision.
The Supreme Court, Ms. Banner, found no gross negligence.
Yes, Your Honor.
No, okay.
Yes, I would want to address Your Honor on that point. The fact is that when you look at the issue of the findings below, that was not a concurrent finding of fact, as my learned friend is submitting to the court. The argument that my learned friend is submitting to the court is that the court below found as a point of law that there was no gross misconduct arising from the concurrent findings of fact. And so there was no concurrent finding of fact with respect to gross misconduct. That was a point of law. The findings of fact related to one.
Sorry, it's not gross misconduct, it's gross negligence.
Sorry, gross negligence or willful misconduct. My apologies. Much obliged, Your Honor, for that clarification. So the court, what my learned friend is arguing is that there was gross negligence was found as a point of law. It wasn't that gross negligence was a concurrent finding of fact. So he said it's a point of law, gross negligence arising from the concurrent findings of fact. Those findings of fact are all in Rosemore's favor. Those findings of fact relate to, one, the fact that Connor Rosemore did not authorize the transaction, that Connor Rosemore had never before communicated using the gmail.com email. The court found that the bank had not demonstrated and had just made a bare assertion, but had not demonstrated that Connor's system had been compromised. And some of the most vital details that I want to point the court to, I will give the page references. In relation to the verification procedure, the findings of fact in relation to the verification procedures as found in the courts below are that, for instance, the Court of Appeal stated that the honest belief by Caye Bank was not sufficient to protect it, as there were red flags that the request for the wire transfer may be fraudulent. These red flags included, and then she goes on, and this is at page 25 of the record, the Court of Appeal judgment. Where it says, in my view, at 48, paragraph 48, in my view, the honest belief by Caye Bank was not sufficient to protect it, as there were red flags that the request for the wire transfer may be fraudulent. These red flags included inconsistencies in the signature on the wire request form, and the evidence is that those were obvious to the eye. The email address jason1rosemore@gmail.com was used for the transaction, which was not on record for Rosemore. The account holder secured domain at rosemore.com was not used, and the large amount of the transfer was above the daily limit and in fact the yearly limit. Further, Caye Bank failed to make further inquiries, such as placing a call to Connor's telephone number on record. Even further, Caye Bank should have been put on inquiry when the person called the bank in relation to the wire transfer. I would say that this was a glaring red flag, as it was Caye Bank who should have placed a call to Connor. So the findings of fact in relation to the verification procedure show that the court, notwithstanding the evidence of Trisha Villanueva, the court found that there were red flags which the bank should have queried and failed to do so. At 41 of the record, the Court of Appeal judgment again, the court stated that there were red flags which the bank should have queried and failed to do so. Further, the court stated there was no evidence that Caye Bank had any anti-fraud controls, that is, that the taken by Caye Bank were adequate, and that verification was proper and exercised with reasonable skill and care. But the evidence from the court below shows that that argument is not, to put it simply, not accurate. The courts found that that verification procedure was not adequate and it was not proper. They have already found that is the case, and it has not been proven that the password to get into the account was known only to Rosemore. That would have, in our humble estimation, required the opinion of a forensic IT expert who was never called. And the fact is, Your Honors, the bank must be astute to the fact that Trisha Villanueva was only one of the officers on this matter. Graniel was the key employee here. And in our humble estimation, the bank did not know its client well enough. It did not attempt to know its client. It gave no evidence that it looked at the client's activity to see what was the volume of transfers. Your Honors, there is in fact a letter in the evidence which shows the instructions from the very beginning of this transaction. It is as page 184 of the record. And that letter actually shows where Mr. Connor writes and says what he expects transactions to look like. And at page 184, the first paragraph, at the second half of that first paragraph, as mentioned in the application documents, billing will normally be on a monthly basis, though a fairly large balance has been built up with the main customer MOV solutions, which will result in an initial large deposit. That is the large deposit that ultimately, initial deposit that went to about 238,000 US. And then he says, once this is paid, I expect consistent monthly deposits of a lower value with only a few transactions on the account each month. He says nothing about withdrawals. So from the very inception, if Caye Bank had known its client, it would have known that, one, it never intended to engage in large withdrawals. It was mostly a deposit account. Two, it had never conducted vast transfers, certainly none to the tune of 70% of the value of its account to anyone. Three, there was no evidence that Yaron David Walter was someone known to Caye Bank. Four, Rosemore.com is the only record that the bank had informed Connor of this, as the bank ought to do, keep updated know your client information to prevent fraud. Then it would have been alerted by all these facts taken together. While we say that the Gmail issue is a sufficient enough issue standalone by itself to have triggered the inquiry, all these facts taken together, when you look at all of them, certainly would have triggered an inquiry.
Ms. Benner.
Yes, Your Honor.
I'm reading here paragraph 106 of the judgment of the Court of Appeal. And they conclude in relation to the submission by Ms. Benner that this was a case of gross negligence. This had not been out by the evidence. There was negligence, but not gross negligence.
Yes, Your Honor.
So how do you deal with that in the context of clause 51?
Yes, Your Honor. I want to draw the court's attention to the depository agreement. If I may just take the court to that agreement so that we may deal with that issue. It is at page 129 of the record. Now, there are two aspects to this, Your Honor. So there's the issue relating to breach of contract, and there's the issue relating to negligence. In addressing the issue relating to breach of contract, what we say, this says the bank shall not be liable to account holder for any action taken or not taken by it under the terms of this document unless directly caused by the bank's gross negligence or willful misconduct. What we say is that this is a provision which is subject to the Queen Square inquiry. So the implied Queen Square duty, this is subject to that duty. Certainly when it says, and His Honor, Mr. Justice Barrow mentioned the term under the terms of this document, that is precisely what we say is a very key point to be made. Because when you say under the terms of this document, it means not only the express terms, but also the implied terms. So.
And one of the implied terms was to properly verify the information that you got.
Once put on inquiry. So the implied term was that 1, I must stop the transaction, and 2, I must make inquiries.
Yes.
And we say, we humbly submit that it was reckless of the bank not to proceed pursuant to that Queen Square duty. And it is not.
You say reckless? You say it was reckless?
Yes, Your Honor.
But the Court of Appeal said it was negligent.
The Court of Appeal.
Words.
Yes, Your Honor. Both the Court of Appeal and the Supreme Court agreed that it was negligent. And I believe the words used, they didn't take care. But that was not the gross negligence is not a concurrent finding of fact, it's a point of law. This court is at liberty to find that notwithstanding the point of law taken by the Court of Appeal and the Supreme Court, that based on the facts that are the concurrent finding of facts by both courts, which have already been established, and the consideration of the implied Queen Square duty, this court is at liberty to find that that amounted to gross negligence or willful misconduct.
So you're saying we may be bound by concurring findings of fact, but not by the qualification that is given by the courts below. But if we think that those facts constitute gross negligence, then we can do that.
Certainly,
is that what you're saying?
Certainly, Your Honor. The court is at liberty to do that. And my learned friend was quite right to express it in a nuanced manner in which he did, which is that gross negligence is a point of law, which is the exact words he used. It's a point of law arising from concurrent findings of fact. But what we say is that when the court is able to look at those concurrent findings of fact, the court is able to come to its own conclusion that this was reckless, it was careless, and they ought to have stopped the transaction, and they ought to have made further inquiries. So the first point we make is that 51B, which is being relied on by Caye Bank, is subject to the Queen Square inquiry. We also say that the clause is far too narrow.
It is subject to the Quincare principle. So are you saying the parties can't contract out of that Quincare obligation or principle?
Mr. Justice Anderson, Your Honor, certainly the parties can contract out of the Queen Square obligation, but in accordance with the JP Morgan case, in order for them to do so, there must be clear words to that effect. And in our humble submission, neither in clause 14 or in this clause can you find clear words that demonstrate that they intended to contract out of the Queen Square obligation. Not even an entire agreement clause is sufficient to contract out of the Queen Square obligation. It has to be clear. And particularly when one looks at these documents that are all prepared by the bank, the contra preferendum principle is at the forefront of Your Honor's minds, in the sense that this document was prepared by the bank. The banks are at liberty to exclude the Queen Square obligation by clear words to that effect.
What would constitute clear words to that effect, Ms. Banner?
Clear words, in our humble estimation, Your Honor, would be that the common law duty of negligence, the common law duty of care for negligence is excluded. The Queen Square obligation is excluded. The banks, in our humble submission, are at liberty to put the terms in these documents that they feel necessary to protect themselves. And so the inference should be drawn, not only the inference.
Would that kind of wording, I'm sorry to interrupt, create any tension with legislative protection of, say, the consumers, Unfair Contract Terms Act or equivalent legislation?
Yes, Your Honor. I agree it does, but that doesn't give the key bank a right to make its provisions so vague in order to try and skirt those legislative provisions, so that customers themselves, have it in their minds one reading, and then the bank has another reading. And this brings me to what Mr. Connor said in his evidence. He said, well, I signed the indemnity. I had no problem with it because it simply indemnified the bank if, based on the instructions they got from us, that they suffered loss. So he said how he understood it. And he said that very early on. So I do understand what Your Honor is saying. Yes, there's a difficulty in terms of those unfair contract terms. But then it means, as Mr. Justice Abel said, it means that the banks must get to work in redrafting their papers. And not only redrafting their papers, but making their drafted words clear enough so that both parties know and can anticipate what those words mean. It is not to simply throw in an indemnity that seems to relieve the bank of every single conceivable action or inaction. It's far too wide. And the cases do speak about this also, a provision that is just far too wide. And in fact, this is dealt with, I believe, in the Chitty on Contracts tab that my learned friend had put in. So in our humble submission, the provision is too narrow. If there was any attempt to exclude, it should have been something that would have been expressly stated, or at least stated to the extent that it could be understandable to both parties, so that Mr. Connor, for instance, could say, okay, I understand very clearly that if someone other than myself uses my signature and requests a wire transfer to the bank, I understand that I will also be responsible for that if I choose to use this form of communication. If Mr. Connor is aware of that, he may then say, I do not choose this form of communication because I do not intend to be liable for someone stealing my signature and whisking money away from me. So what I think is important is the way the law has developed, and rightly so in our humble submission for JP Morgan, is that in order to exclude the Queen Square obligation, it must be clear.
Counsel.
Yes, Your Honor.
Sorry, just for my own edification, is there an unfair contract terms act in Belize?
Your Honor, I could certainly obtain that information for the court. Unfortunately, if I am giving about 5 minutes, I could probably do so very quickly.
No, I myself had checked and was under the impression that there was no such act in Belize. But if you could double check.
Yes, Your Honor.
Thank you very much.
Yes, Your Honor. May I be permitted to just?
Yes, thank you very much. Yes.
Very much obliged.
But maybe you could finish your presentation and then just later let us know if there is such an act.
Very well, much obliged, Your Honor. I won't be much longer, Your Honor. I just wanted to go to just some reply points.
Yes, well, Mr. Knox got some extra time, so you should have some extra time. We're out of the hour now, but maybe yes, 10 minutes or so.
Much obliged, Your Honor. That would be sufficient. So just to go to some points of reply, Your Honors. So the point we're making really is that insofar as clause 14 is concerned, the account holder must request the wire transfer. It has been proven and there are concurrent findings of fact that the request was not authorized by the account holder. Now, Caye Bank says that clause 14 excludes the Queen Square obligations, and we have outlined in full at 7 to 24 of our submissions why we say how clause 14, we express how clause 14 ought to be interpreted, so we won't belabor the point. We say in summary that it is a conjunctive requirement. It is that Caye Bank must receive authorization from the account holder. That is a threshold requirement that must be passed. And the learned trial judge found at page 95 of the record, paragraph 174, that Rosemore did not authorize and was not implicated in the transfer of the funds. The court also found as a fact that the transaction was processed by Caye Bank at the behest of a third party, likely Yaron David Walter, who was implicated in the transaction. It is a factual finding which has not been interfered with or reversed. And in our humble submission, because of that failure to climb that threshold requirement, Rosemore immediately falls outside the ambit of clause 14, in the sense that the court ought not to move on to consider whether the signature was satisfactory to the bank or verification procedures, etc. Notwithstanding that, what we say is that Caye Bank admits in its reply submissions at 2.1 that clause 14, and I quote, it permits Rosemore to give instructions to move monies into and out of its account. But Your Honors, that is no different from what Rosemore is asserting, which is that the clause is directed to Rosemore, not any third party having that right. So what we say is that since Rosemore did not authorize the transfer, the bank cannot say that the lack of authorization by Rosemore does not matter because we thought Rosemore authorized the transaction. That is not what the bank is permitted to say. So moving on, if you move past that threshold requirement and the court says, okay, but we need to consider the signature must be verified or the identification must be provided, which is satisfactory to the bank. Again, at 2.2 of Caye Bank's reply, Caye Bank agreed that upon receipt of a wire transfer, it will act upon it either upon verification of signature or upon identification satisfactory to the bank. So what we're saying is that when you read 2.2 of the reply, Caye Bank agreed that upon receipt of a wire transfer, you must imply there a wire transfer request from Rosemore. It is not just any wire transfer that comes to the bank. It has to be a request from Rosemore. There is no evidence that Caye Bank carried out these exercises, well, we know that it did not carry out the identification exercise because it never requested, for instance, Mr. Connor to send a passport, a copy of his passport. We know that they relied singly on the verification of the signature, the photocopy signature, sorry, the electronic signature to verify the transaction. Now, the bank is not limited, and this goes to a question His Honor, Mr. Justice of Appeal Burgess asked. The bank is not limited in scope by clause 14 in terms of the exercises that it must undertake. This is because where the bank is put on inquiry.
Excuse me a minute. Could you give me just 2 minutes? There is a pressing matter at my door. Just 2 minutes, please.
Certainly.
Court, please.
Okay, so we will pause for 5 minutes. Then you have time to find the to find the act if there is any,
Yes,
and then
sir.
we continue.
Much obliged.
In 5 minutes, we will continue in 5 minutes.
Much obliged.
Yes. Justice Barrow. Okay, well, anyway, Ms. Benner needed some 5 minutes to look up to see if she could answer the question of Justice Burgess. So I suppose the 5 minutes are almost over.
Yes, Your Honors. I was able to look at the laws as updated, and we have no such act. We do have a contract act, but it doesn't have any provisions based on the searchable version of unfair contract terms.
Great, thank you. Then you can finish your...
Yes, Your Honors, I won't be much longer. Just some quick points. So what we say, and before I went off, there were two issues. There was two issues that I said I wanted to address with respect to 51. One was the breach of contract issue, which I had addressed. The second, the negligence at common law issue. What we say is that when one looks at clause 51, it's specifically referable to the terms of the document. So I don't see how it could be argued that one should transplant a clear wording in that clause that it is referable to the terms of the document and transplant it over to the common law of negligence. In our humble estimation, that is not what it means to say that there's a coextensive duty. Once you find in contract, you must find in court. In common law negligence. I will touch on that briefly, but to go on where I left off, what we say is that Caye Bank was put on its positive duty of inquiry under the Queen's Care principles. When you look at the objective test judged by the standards to be applied by an ordinary prudent banker, this is because it had reasonably grounds, not necessarily proof. That is not what the case law requires, but it had reasonable grounds for believing that the wire request was, being made by perhaps someone who was not the customer's agent. In those circumstances, Your Honors, we say that what Caye Bank ought to have done was to invoke a higher verification procedure than 14 calls for, clause 14. So it's a negative and a positive obligation, first to stop and then to inquire. And we also say that that obligation is not excluded or negated by clause 14, that clear words are required to nullify that quint square duty. What we say is that the ordinary prudent banker would know his customer, would be familiar with his customer's habits and tendencies as revealed by Rosemore's records, and that the ordinary prudent banker would have been triggered by the many, what we humbly submit were glaring factors known to the bank, whether through Ms. Graniel, who dealt directly with the third person, or through other bank officers. In terms of the reply to the submissions filed by my learned friend, the particular points of reply. Now, what my learned friend refers at paragraph 2 of the reply to what he says the 14 consists of 4 main parts. With respect to, we've already dealt with 1 and 2. With respect to 3, we say that's fairly obvious. And 4, the question arises as to who is responsible for the processing of a wire request. And that is, as the court below said, it can be none other than the bank. And on a plain reading of 4, it refers to the fact that no third-party requests for transfers will be processed by the bank. And third party, of course, in its natural sense, refers to someone other than the parties to the agreement. In reply to paragraph 3, the italicized words, upon verification of signature or upon identification satisfactory to the bank. Caye Bank argues that the question is not whether the identification provided is in fact genuine, as long as it appears to the bank that the bank took its task on with reasonable care, and the bank acted on it. And our response to that is that if the bank were to accept that approach, that it matters not whether the signature is genuine, that would be firstly a rudimentary approach. The bank is aware of the risk. When you look at paragraph 4 of the appellant's own grounds, where it says, in paragraph 4 of the appellant's own grounds, they say it appears to have interpreted it as imposing the same obligations on the appellant as if it was dealing with non-wire transfers, even though the risk inherent for a bank in dealing with such are different. So on its own grounds of appeal, the bank is saying that the risk inherent for a bank in dealing with wire transfers are different. We would assume that they mean different because of the nature of bank fraud, online bank fraud, and how easily those can be conducted. And we say that as a bank, if you appreciate the difference, you must ensure that you have proper, reasonable verification procedures. And certainly, scanned signature is not sufficient verification, particularly because if you are to compare that signature
I
to...
rather suspect, Ms. Banner, that you have told us these already, you know.
Pardon me, Your Honor. Let me just scan very quickly, Your Honor.
I think you should conclude now.
Yes, much obliged, Your Honors. Just on the fact that, Your Honors, that Caye Bank will not see an original signature makes it inherently untrustworthy as a means of taking instructions. There were just a couple points that I wanted to very quickly draw the court's attention to that I did not reference. Perhaps it might be helpful if I send my speaking note. I don't know if that would be helpful to the court with respect to the burden of proof and the other points that were made.
The point
with
is
respect, Ms. Banner, I don't know that the burden of proof has anything to do with anything.
Yes, I was of the same view, Your Honor, but I note that it's a ground.
And Mr. Knox didn't make any submission in that regard.
Very well, Your Honors. Your Honors, so all in all, that concludes our position with respect to this matter, that certainly Rosemore is entitled to the return of its funds and damages and interest as paid.
Thank you very much.
May not be of any further assistance then. Much obliged.
Thank you. Mr. Knox, reply.
My lords, if I may just briefly, in answer to my learned friend.
We like the word briefly.
Yes. Clause 14. In my submission, the fundamental question is this, underneath everything else. How would the matter have appeared to the bank at the moment it made the transfer on the 23rd of April 2015, given what it then knew? For that purpose, the court must scrutinise the precise sequence of events and what the bank knew and what was it reasonably entitled to assume, given its online banking portal securities. Now, first, if I can deal with the signature point. Ms. Banner says that there were visible differences, and she relies on the Court of Appeal's judgment, where they say that the naked eye, essentially the Court of Appeal says visible with, quote, the naked eye, paragraph 99. That was not the expert evidence. The expert evidence did not say a normal bank official could see it, just didn't say that. She was talking about what she could see as an expert. And it's not, I might add, what the trial judge said. He talks of the, quote, possible visible differences, not seeing the possible visible differences. That's 102C. Second, and I therefore submit, given all the other points I've made about the point not even being put to Ms. Villanueva, there is a plain error in the court's findings in saying that the bank should have spotted those differences. Differences there were, but not such that the bank was negligent for failing to spot. Therefore, the court can review the matter afresh because there is an error, and I submit quite an important error in the decision of the courts below. And we say, quite simply, there being no evidence or even charge against Ms. Villanueva that she was negligent in this respect, that finding must go. I then come to the Gmail point. And what I submit about the Gmail point is this. Very, very important to see the sequence of events. I've already gone through it, but I might just be helpful if I could show you the documents by which the original request came in from the admin at rosemore.com. And that is at 387. If one goes first to 387, just want to show you 387. Because my learned friend referred to this and to the conversation, but it cuts both ways, that point, about there being a prior conversation. 387, you have the email coming through the banking system, the online portal, quote, from admin@rosemore.com. This says 11:21 on the 22nd of April 2015. So this is something coming into the bank. And then you work out, then you want to find out what the message is. And the message is the one which you see at 186. Go back to 186. Right, saying it's 186. Sorry, not 186, 188. Yes. This appears to have a different time zone, 12:20 as opposed to 11:20. But you can see the actual message, and you'll see it says from Rosemore International Limited. And then you'll see, good morning. Here is my wire transaction instructions as per our conversation. And then you have the transfer at page 189. So that's how matters develop. But just note at 188, as per our conversation. So obviously the imposter, the fraudster, has had a word that's quite clear with the bank before sending this. I accept that. But the important point is he's into the banking portal, and he is writing from admin@rosemore.com. So the bank, in my submission, is perfectly entitled to assume that the chap who's had this conversation is
Mr.
obviously
Knox,
kosher. Yes.
Mr. Knox, I think Justice Anderson lost the system. So if you could pause and maybe we can get him back so he can hear what you said.
Yes, yes.
Yes, sure.
Justice Witt, we may need to take a 5-minute break for that, please. Thank you, Judge. Could we do that?
Well, it's, yeah, if we have, there he is.
He's back?
Okay,
thank you, Judge. Thank you, Judge.
Thank you, Registrar.
Okay, please continue, Mr. Knox.
Yes. Just looking at 188, my learned friend is quite right to say that the initiating conversation, or the initiating communication was indeed orally, over the telephone, presumably, by the imposter to the bank. But then he immediately follows that up, or on the same day, follows it up with a message through the online banking portal. So he's obviously somehow got the password, secret password, and he's writing from admin@rosemore.com. So he's somehow got into the proper Rosemore email system. Now, I say it's very important when assessing the bank's knowledge and conduct to bear in mind that that is how the thing started off. And then the next document you need to go to, if I may, just so you can see the sequence, at 186, same day, at the foot of 186, or rather not the foot, but the last document in 186, or the last box, you'll see 3 lines from the end, date 04/22/15, 1:23 p.m. CDT. As I understand, that means clear of daylight time. And this is here again at the crook. Confirmation, good afternoon. I'm only reminding you that I'm travelling and only have access to my personal email. Now, I have, of course, Mr. Justice Burgess' point about that. Kindly send confirmation to that one, and when received, I will call the bank. So that's what he asks. But then one wonders, well, what does the bank do? Well, in fact, it sends the confirmation to the proper address, the admin@rosemore.com address. And you see that at 333. So it doesn't, so to speak, send the confirmation that it's going to act on the request to the dodgy email. It sends it to the correct email at 333. And there you see that it's rather in the second part of 333, subject low priority secure message. And that's picking up what was said on the very opening email the bank received from the imposter. Then you'll see the date of this is 23rd of April, 10:11. Click here to use your to your user password account to view the message. And if you then do, as it were, if Mr. Connor, let's say, had received this and had clicked, and we know he did receive it, if he'd clicked, what he would have seen is what you see at 186. I'm sorry it's all over the place, but this is how the documents are attached to the witness statements. At 186, going back to 186, it's the second box, and this is the first bit of the second box, and this is where the bank is saying, if you click, as it were, good morning, I apologise for late response. That's Miss I think Graniel, had to leave unexpectedly yesterday. Your wire request will be processed today and confirmation will be sent to your, quote, personal email. Safe travels, Floor. So at this point, the bank is confirming and sending a confirmation to the correct address. It's not sending it to the dodgy address. And that, in my submission, is very important. It's not, so to speak, relying on the dodgy email address to give the confirmation of the transaction. And that is at, as you can see, I think I'm right in saying, it's at the time which I mentioned before, 11 minutes past 10 on the 23rd of April. So what I submit, as far as the bank is concerned, in the process of transferring the monies, at that point it's done what I submit is followed a perfectly correct procedure, and the Gmail address is irrelevant for the purpose of following that procedure. Now, Mr. Connor accepts he did get that email, and you see that at 216, page para 22. He does get it, and he says so.
Sorry, what page is that, Mr. Knox?
216.22.
But he said he clicked on it, but he couldn't get in or something like that?
Yes, that's right. Well, the way he puts it is in 22, the important point I just want to emphasize for the moment is he did get it. So it was, as it were, received. What's not clear is precisely when he tried to click in. But we know because we know by the 28th of April, he was not able to get in, and he complains to the bank. What he doesn't say, and what's not totally clear, is when he first tried to click in. But I'm, for the moment, not trying to blame Mr. Connor for anything. All I'm trying to do is say, how did things look to the bank? They have sent, what, as far as they are concerned, is a valid email back to someone who's made a valid request from a valid email account through the online portal. So that's how things look to the bank. As with everything, when there's a crook involved, both sides' points look perfectly reasonable. And then what you're trying to do is work out, well, where does the balance fall? But that is, in my submission, is the important point. 10 past 10. And then it's only 4.5 hours later that the bank sends a confirmatory email, also or later, to the dodgy address. And that's at 543 of the same bundle. And you can see it's difficult to interpret the second half of this. It looks as if the bank itself, the second half of this page, looks like a communication from the bank internally to Ms. Graniel. Access money manager wire confirmation alert wire sent to account. So it looks as if they're saying the money has now been sent. But anyway, Ms. Graniel, more importantly, at this point writes at 2:30 p.m. Good afternoon. Kindly see below the wire confirmation. So she confirms to the dodgy address what she'd already confirmed to the good address. And then the imposter says, I'll call you back later. Now, I submit that's the context in which one has to consider the construction of clause 14. And you have our submissions. But I say it's very important to bear in mind that sequence of events. Just dealing with the password point, my learned friend says we don't know whose system was broken in. It could have been the bank's, and therefore, by implication, it is being suggested the secrecy of the password could have been compromised because of some default in the bank's own system. Now, first of all, the short answer to that is the judge himself said it's not established either way. Can't tell. But secondly, and more importantly, the bank, as far as the bank's concerned, it's entitled. There being no evidence, it's not being put to it that there were lots of break-ins in the past. The bank is entitled and is bound to assume that the secret password hasn't been compromised, subject, of course, to any special factors. But otherwise, no bank could ever act on anyone's instructions. So again, in my submission, the bank's entitled to take it on the basis of it that this is a valid instruction coming through a secret password portal. Now, my learned friend, so those are the points I particularly wanted to make on the facts. My learned friend talks of the quince care duty. She says, well, our argument doesn't take into account the possibility that it was someone else at Rosemore who had somehow got hold of the relevant documents or broken into the portal or sent the emails. Well, my lords, your honours, the short answer to that is in my submission at page 126 and clause 21D, which I did mention in my opening. But if I can just ask you to look at that, because this is important, because I submit 21D does exonerate the bank from making inquiries along the lines, there may be someone, it may be someone within the company itself who's acting crookedly. You'll see it says the bank shall have no duty, responsibility or duty to monitor such an account or the use of funds paid from it, nor any liability for any act or omission by any person who signs the signature card. So this, of course, is not a complete answer, but in my submission, it answers the point that the bank was bound by the traditional quince care duty of making sure there weren't bent directors. And therefore, it didn't have to say to itself, well, this could be someone at Rosemore who's acting crookedly. That was not something it had to say to itself. My learned friend talks about gross negligence, and she says, well, it would be open on the clause 51 point, it would be open to this court to say that there was gross negligence in any event. Well, in my submission, that, with great respect, my learned friend, is a hopeless point. First of all, we have squarely put clause 51 at the heart of our submissions, or close to the heart, and there is simply no cross appeal by the respondent to the effect that there should have been a finding of gross negligence, nor is the point even taken in my learned friend's written submissions. And that, I think, if one goes to page 1670 to 1674, my learned friend quite rightly and understandably takes all sorts of points about the construction of the agreement and so forth, but not once is it said that the courts below should anyway have found gross negligence. Secondly, that is a very serious charge indeed. And if it were to be pursued, my clients would certainly be entitled to have it clearly put to them before the hearing takes place, rather than find that it's been made in the course of an argument which they have limited time to respond to. It's one thing to be found negligent. It's quite another thing to be found grossly negligent. That has serious reputational implications. And obviously, I haven't come specifically prepared to deal with any such argument. As far as the construction of clause 51 goes, my learned friend relied on the contra profferentum argument. Well, I accept in principle it could apply, but it doesn't apply where the words are clear. And for the reasons I've given, I say the words are clear. Secondly, there is a discussion about the possibility of consumer contracts, Unfair Contract Terms Act, and so forth. Can I just very briefly, and I think it's my last point, ask you to look at what Lord Diplock said about these types of clauses, that's to say exclusion clauses, in the photo productions case at 1532 A to C of the bundle. (1532) A to C. This was a case which in part turned upon exclusion clauses and fundamental breach and other matters such as that. 1532. well, perhaps one can pick it up at 1531 G. Since obligations implied by law in a commercial contract are those which by judicial consensus over the years or by Parliament passing a statute have been regarded as obligations which a reasonable businessman would realise as accepting when he entered into a contract of a particular kind, the court's view of the reasonableness of any departure from the implied obligations which would be involved in construing the express words of an exclusion clause in one sense that they are capable of bearing rather than another is a relevant consideration in deciding what meaning the words were intended by the parties to bear. In a sense, that's Mr. Justice Burgess's point. One has to sort of be reasonable about these things. But, and this is what I particularly rely on, this does not entitle the court to reject the exclusion clause, however unreasonable the court itself may think it is, if the words are clear and fairly susceptible of one meaning only. My lords, the reports are full of cases in which what would appear to be a very strained constructions have been placed upon exclusion clauses, mainly in what today would be called consumer contracts and contracts of adhesion. As Lord Wilberforce has pointed out, any need for this kind of judicial distortion of the English language has been banished by parliaments having made these kinds of contracts subject to the Unfair Contract Terms Act. In commercial contracts, and this is obviously what I rely on, negotiated between businessmen capable of looking after their own interests and of deciding how risks inherent in the performance of various kinds of contract can be most economically borne, generally by insurance. It is, in my view, wrong to place a strained construction upon words in an exclusion clause which are clear and fairly susceptible of one meaning only, even after due allowance has been made for the presumption in favour of the implied primary and secondary obligations. So there you have in my submission the correct approach to what you might call the conflict between normal implied terms and clarity of an exclusion clause. And you have my submission on that, but I say that's the correct approach. And I say that being so, the bank's case on clause 51 is with respect, very difficult to overcome.
Thank you very much, Mr. Knox. We will, of course, consider all the arguments. It seems to be a very interesting case with important aspects, so we will look carefully at them. You also understand that soon enough the court will go into a recess, so you can understand that a decision can only be expected maybe in the latter part of the year. But when we are ready with a judgment, then we will notify the parties and deliver a judgment. So thank you all for today, and we can close off, Madam Deputy.
Your Honor, my apologies, Your Honor. I just wanted to draw Madam Justice's Rajnath Lee to the page 188 that I had promised. And my apologies for interrupting. I just wanted to draw Madam Justice Rajnath Lee to the page I had mentioned I would direct Her Honor to.
Great, 188.
Regarding the prior conversation.
Thank you very much.
Much obliged.
Madam Deputy Registrar, we can close off.
Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. Thank you, Counsel, and thank you to all staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.